I'd like to begin by paying my respects to the Yagara and Turrbal people and to their elders past, present and emerging, and also to any Indigenous people in the room with us today. Murray, should I use the mouse? Slides don't seem to be working. There we go. It's a man-made volcano, mate. They've turned this place into Mordor. They were the words of Jack Green, a Gurrowa elder, lawman, artist and conservationist. He's the man pictured painted in ochre on the screens behind me. He was my soon-to-be client and friend, and I was about to see for myself. As we rounded the corner in the Carpentaria Highway, I came face to face for the first time with the infamous Macarthur River mine, bellowing sulphur dioxide from its enormous waste rock dump. It was indeed as though we had arrived in Mordor. The plume of toxic sulphur dioxide smoke went for kilometres, this spectacular spontaneous combustion allowing us a glimpse inside the potentially catastrophic issues which lay beneath that man-made mountain.
Three years ago, a plume of toxic sulphur dioxide smoke revealed pyritic rock was burning in the waste rock dump.
This is sort of unprecedented. I don't know of any other case in Australia that's got to this level of problem on this scale.
Imagine for a moment waking up to the stench of sulphur dioxide in your nostrils. Imagine the stress associated with fishing in rivers and creeks, and then finding out that fish in those same rivers and creeks exceeded the food health safety standards for lead. Imagine the uncertainty of being told that a mine that was supposed to be there for 25 years would have impacts forever. Imagine a community divided by a project they never wanted. Imagine the pain and trauma associated with the destruction of sites sacred to you and your people, your cultural responsibilities trampled where they had been upheld for thousands of years. These aren't fantasies for the people I represented in the Gulf. They are day-to-day realities. The images of the burning waste rock dump at Macarthur River, which you've just seen, are sensational. They made their way across the globe. The world's second largest zinc mine on fire, a volcano. The temperatures inside the dump reaching hundreds of degrees. It was an angry scene, and that reflected the anger of the people living in the vicinity of the mine. Working with those people would in large part define my time as the head lawyer at the Environmental Defender's Office in the Northern Territory. And it was here, I think, that I began to shape my views about impact assessment and its impact on people and place. The Gulf is an area rich in biodiversity and history. It's a remote and stunning part of Australia. The landscape is harsh and rugged. It's some 750 odd kilometres to the nearest capital city, Darwin, and the area is often cut off during the torrential rains of the wet season. The Macarthur River, a major tropical river, finds its headwaters in the Barkly Tablelands and then flows some 240 kilometres to its mouth in the Gulf of Carpentaria. The Macarthur River and its tributaries provide refuge for many flora and fauna, many of which are listed as endangered, threatened or vulnerable. The mine's history is filled with controversy, a combination of politics at its worst, a company hell-bent on making its money, a failure of impact assessment and a complete disregard for Indigenous views and culture has seen this catastrophe go forward like a train wreck in slow motion. I came onto the picture late in the scene in 2013, and by that stage the train was well and truly derailing. The Macarthur River mine sits atop one of the world's largest zinc deposits. It's also got lead and silver in it. The resource proved for many years to be uneconomically viable, but was finally exploited by underground mining between 1995 and 2001. By 2001, the mine had exhausted all or most of its accessible ore from underground mining and was running at a severe financial loss. And in August 2005, Macarthur River Mining submitted its first environmental impact assessment for the project, proposing the conversion of the mine from an underground operation to an open cut one. Most controversially, the project proposed the diversion of a 6-kilometre stretch of the Macarthur River. In February 2006, the Northern Territory EPA recommended that the project be refused. They stated the outcome of the environmental impact assessment for this project is that the EPA is unable to conclude the project can proceed without unacceptable environmental impacts. The EPA is not confident that mining at the site can be managed with minimal long-term risk to the environment adjacent and downstream of the mine site. On the 23rd of February 2006, the NT Environment Minister agreed and refused to recommend the approval of the open cut project, citing significant uncertainties associated with the long-term impacts of diverting the river and open cut mining within the riverbed and floodplain. Almost immediately, Macarthur River Mining had another bite at the cherry, submitting an amended proposal with the blessing of the Northern Territory and Commonwealth governments. The second public environment report, an expedited process designed to limit the extent of public consultation, was again reviewed by the Northern Territory EPA. It again found substantial issues, including with respect to community opposition and the remediation of the environment. While some improvements were noted, the substance of the original EIA had not changed. The major risks remained. Despite this, the open cut project was approved by the Northern Territory Government in October 2006 and by the Commonwealth a week later. Both of the impact assessments were generally thorough. They allowed the EPA to identify serious risks associated with the project, the risks associated with the river diversion and the integrity of the diversion channel, the inadequacy of the proposed construction of the tailings facility, risks associated with the mine's proposed location in the primary channel of a major tropical river. These were all identified. The assessment's most damaging flaw was its approach to waste rock characterisation and the conclusion that followed, namely that approximately 89% of the waste rock would be non-acid forming. The approach taken to waste rock classification, relying on visual classification, was not best practice. Why the company and its consultants chose to pursue that method of identification, I don't know. But the sceptic in me wonders whether this mine would have ever been approved if the truth had been known. If it were public in 2005, that in addition to all of the other risks, an accurate breakdown of waste rock characteristics would have almost reversed the estimate in the impact assessment. In truth, we now know that over 80% of the waste rock on the Macarthur River mine site is problematic. In government briefings in 2015, which we obtained through Freedom of Information, it was revealed the government had been informed the mine's problems could have potentially catastrophic consequences, that 400 cattle had been shot because of potential exposure to lead, and that Glencore didn't have a design or sufficient clean fill to manage the waste rock on the site. The Northern Territory's regulatory framework for impact assessment is deeply, deeply flawed. But one can't fault the impact assessment process entirely. Other factors were at play, as they so often are. In a 2010 essay about the process, Kirsty Howie wrote, "Politics played a major part in the chaotic assessment process. The relevant decision makers were placed under considerable pressure to expedite the assessment and approve the project. One is left with the distinct impression that two governments determined that the mine be approved despite the environmental risks, and the Northern Territory assessment regime, accredited by the Commonwealth, was sufficiently flexible for this to occur. There were a number of respects in which credibility of the assessment was seriously compromised, but it's probable the manoeuvres were within the scope of the legislation." Some 14 years on from that initial assessment, the Northern Territory's legal regime remains largely as it was then. It's an indictment on the governments that have been in power during that time. I do note that there is a regulatory reform process there at the moment. I also note that they abandoned third-party merits review, having heard the concerns of industry during the public consultation period. The problems I articulated, a combination of politics at its worst, a company hell-bent on making its money, and a failure of impact assessment, all contributed. So what must we learn from those things? What must we change to see it avoided in future? We offer 3 suggestions, which are of general application. They are interlaced and work together. The EDO has been advocating for changes like this for a long time. First, we must break the nexus between project proponents and their consultants. In impact assessment, there is a clear conflict of interest between being paid by a proponent and providing an impartial assessment of that project's impacts to the environment and people. In a 2019 article, William Lawrence makes a convincing argument about the role scientists have played in the failures of impact assessment. In that critique, he includes the following remark: most assessments are short-term and myopic in nature and systematically biased towards project approval, partly because a project proponent must pay for the assessment and thereby has a manifold means to influence its outcome. At the EDO, we have consistently argued for a framework which establishes an independent pool of consultants accredited by government and then selected at random to work on a particular project. Second, consultants should provide a statement of compliance with best practice. Imagine if the regulatory framework required and made enforceable with sanctions, like the loss of accreditation, that a consultant must provide such a statement to a decision maker, and then they in turn were obliged to consider it. Often the inadequacies of impact assessments can be found, but they're buried within thousands of pages, and they're certainly not drawn to your attention when you read the executive summary. If you knew right up front that a species survey was too short or that it occurred at the wrong time of year, and you had a brief description about what the consequences that might have, perhaps a proponent would just get the survey done properly, or perhaps a decision maker might ask for more information, delaying the process. If you knew right up front that a proponent was using an outdated methodology for assessing waste rock characteristics and that the consequences could be catastrophic, well, maybe I wouldn't be here talking about the McArthur River mine. But in a hyper-politicised environment, even those two safeguards won't be enough. They mightn't be enough. We need a third mechanism to coexist with those other two. And I speak of recourse to an independent court empowered to interrogate the merits of a decision to approve or not approve a project. I cannot overstate the importance of merits review rights provided to third parties. It's a safeguard against corruption. It's a mechanism to improve the quality of decision making, and it's a tool for increasing community confidence in environmental impact assessment and the decision making process which follows. In 2013, despite its unsatisfactory environmental record, and after another environmental impact assessment, the Northern Territory Government approved the so-called Phase 3 expansion project. The expansion, more than doubling the mining rate, expanding the footprint of the open pit, increasing its depth from 210 metres to 420 metres, expanding the tailings storage facility, and expanding the waste rock dump to store an additional 530 million tonnes of rock. The mining management plan included a reclassification of the waste rock, with total problematic waste rock constituting up to 89% of the total waste rock mined. After the reclassification, the Northern Territory EPA decided a new environmental impact assessment was required for the management of the waste rock. It was also given information by the Northern Territory Department of Mines and Energy suggesting that MRM had already placed large quantities of non-benign rock below the 1 in 100-year flood levels. In terms of impact assessment, you would be wrong to think that McArthur River mining's practices had improved much since the original EIS in 2005 and the PER in 2006. From 2014, I acted on behalf of a large group of traditional owners and community members to make public comment on the overburden management project, the latest EIS prepared for the McArthur River. That new project necessitated by the need to change fundamentally the management of the mine to deal with the waste rock issue. And it's here I'd like to turn my focus to the other impact of the McArthur River mine story. Although to my clients, these impacts are one and the same. I speak of the impact of the project on culture. In a recent article, Jack Green and Sean Cairns discussed cultural resilience in the Gulf, and they described the cultural attachment of people to their environment. Indigenous cultures in the Gulf are inseparable from the environment. People imbue the environment with meaning-making practices that define terms and values that regulate social life concerning the economy, ecology, personhood, body, knowledge and property. Their unique ethno-ecological identity, a social identity shaped by their unique human and environment relationships, is essential to understanding their life project. This entwined nature of the interaction of identity, culture and country has been a common factor of my experience working with Indigenous peoples. It's a worldview which challenges the existing paradigm of impact assessment, the typically Western notion of a hyper-separation between humans and the environment. Before he passed, shortly after court proceedings, the lead applicant in litigation which challenged the approval of the McArthur River mine becoming open pit, Harry Lanson, described the pain he would endure if the mine would proceed. If they're going to make a big river down there, a big dam, they're going to kill me. My spirit's there, you know, my song and my spirit. I'll be sick if they cut that place. You know, my spirit's there, all my songs for crossing that river. The final environmental impact statement didn't include a standalone social impact assessment report at all. Rather, it contained a stakeholder consultation report and a socio-economic environment report. Neither could be considered as coming anywhere close to best practice. Its deficiencies are not a surprise, even less so given the company involved. But my experience is that most proponent-driven social impact assessments aren't worth the paper they're written on. And without changes to the legal frameworks that require them, I don't think that's likely to change. Our clients made many criticisms of that social impact assessment, if you could call it that. They included inadequate timeframes, failure to address issues of community division and social cohesion, failure to meaningfully engage with people in such a way as to allow them to accurately understand the project, and failure to provide resources to allow them to have that independent understanding, interpreters, independent legal representation, independent technical assistance. The Northern Land Council's submission put it more succinctly than I can. There is no way of determining from the EIS what relevant Aboriginal people actually think, because the consultation process and the manner in which it is reported are flawed. Underlying all of this is an impact assessment framework, which, like many, requires consideration of social impacts, but does not mandate how. A framework that has tried to do it differently can be found in New South Wales, which is where I turn to now. I previously said I wondered if the McArthur River mine would have been approved had the original EIS accurately stated the percentage of problematic waste rock that would be found on the site. I've wondered too if it would have been approved if the legal framework had provided for the minister's decision to be reviewed by a court on its merits, or if they had had to factor in a rigorous social impact assessment that truly considered cultural impacts. Those questions and the importance of social impact assessment and merits review came into sharp focus on the 8th of February this year, with the Chief Judge of the Land and Environment Court in New South Wales handing down his landmark judgment in the case of Gloucester Resources versus the Minister for Planning. The EDO was engaged to act for a diverse group called Groundswell Gloucester. That assortment of farmers, local business peoples, retirees, traditional owners and more were united in their opposition to a proposed open-cut coal mine. The mine was proposed for the scenic and serene valley of Gloucester, which you can see on the slide. It's described by some as an idol. The Rocky Hill project came along at a time when the community of Gloucester was already exhausted following a 10-year battle against AGL's proposed gas field in the area. The interaction with the impact assessment process was described by our clients in Gloucester as one of frustration and disempowerment. The case reached the court after the department recommended refusal of the mine, and the consent authority agreed, citing visual impacts and inconsistency with the area's town planning zoning as factors justifying the refusal. But it left it open to the mine to appeal the merits of that decision in the New South Wales Land and Environment Court. In a delicious irony, the merits review allowed our clients to interrogate in exquisite detail the expert reports, impact assessment and social impact assessment put forward by the proponent, and to put forward our own evidence about climate change impacts. Importantly, we were able to contrast the mine's experts with our own. The judgment justifiably made headlines for what it said about climate change. It did create a worldwide precedent because the judge cited climate change as a reason for refusing an open-cut coal project. But what it says about social impacts is equally important. They were, in the judge's own view, the better reason for refusing this project. In New South Wales, social impacts must be considered as part of the overall environmental impact assessment. But like many regimes, the Act doesn't provide guidance on how. The court in the Rocky Hill case was therefore obliged to consider social impacts, but in the absence of guidance in the Act, turned to the guidelines and applied them, taking into account the contradictory evidence of social impact put forward by our client's independent expert, Dr. Hedda Askaland, and the government's Dr. Rebecca Lawrence. The New South Wales Government's release of the guidelines in 2017 represented a significant step forward in terms of how social impacts are to be assessed and factored into decision-making in New South Wales. The guidelines seek to address the New South Wales significant distrust in the application of our planning laws, and it also seeks to establish an objective way to transparently manage and factor into decision-making the social impacts of projects. The guidelines have many positives. They usefully state principles and requirements which assist to better protect communities and also provide a way for Indigenous views and aspirations to meaningfully find their way into the assessment process. In Rocky Hill, our clients, through their experts, were able to show how the mine would be felt by the community. Issues such as distributed inequity, seldom previously considered, were dealt with at length. The impact on people's sense of place, the impact of their fears, all formed part of the evidence. I commend the judgment to you, both for its climate change, what it says about climate change, and for what it says about social impacts. The Chief Judge applied the guideline using a 4-step process which closely follows the logical flow of the guideline. His interpretation of the guideline provides a useful framework for the assessment of social impacts for a project which goes beyond a ticker-box approach. It is thorough and provides a frame through which differing worldviews can be balanced and understood. It is a mechanism through which mainstream laws can move closer towards an understanding and actual recognition of the unique ethno-ecological identities of Aboriginal people. Importantly, the guideline has also provided a basis for the court to accept fears for future generations as a legitimate matter for consideration in social impact assessment, for example, in respect of climate change. It is trite to say that climate change will revolutionise impact assessment, whether we like it or not. This conference poses a question for all of us here, and at some point the slides will catch up and also ask that of us. There we are. Do we need evolution in this space or revolution? The objectives of impact assessment are to ensure environmental considerations are explicitly addressed and incorporated into development decision-making, to anticipate and avoid, minimise or offset the adverse significant biophysical, social and other relevant effects of the development proposals, to protect the productivity and capacity of natural systems and the ecological processes which maintain their functions, and to promote development which is sustainable and optimises resource use and management opportunities. It is safe to say that the objectives of impact assessment were not achieved in the McArthur River Mines case, to devastating effect for both the environment and for culture and communities in the Gulf. I once asked Jack Green to describe for me the impact of the diversion of the McArthur River. He said it was like cutting out the heart of a spirit. He described it as the most sacred book you could imagine, which needed to be passed on but couldn't be. Imagine that book and tear out the middle. The story doesn't make sense anymore. Unfortunately, the story at McArthur River Mine is not an isolated example. The moral of the story is one of general application. The impact assessment process is a system out of balance. In most places, environmental impact assessment remains a tool of powerful political and economic interests, a rubber stamp. A recent paper published by the Alert Group lists a number of disturbing examples where, as they put it, EIAs are giving the green light to developments that should never see the light of day. I declare myself a revolutionary, but not because of the radical changes I suggest. I have argued for breaking the nexus between proponents and consultants through a randomly selected pool of accredited specialists, for a requirement that all consultants provide a statement of compliance against best practice, for third-party merits review rights to be a feature of all impact assessment legislation, and for mandatory social impact assessment, which would see cultural and community considerations appropriately at the heart of impact assessment. And I suggest the New South Wales guidelines are an excellent start. One might very well argue that those changes are simply incremental, that they really shouldn't change things very much at all. But in reality, we know that's not true. In Gloucester, our clients nervously await a potential appeal on the Rocky Hill decision due to be filed by next Wednesday. In Borroloola, my old clients await the outcome of the overburden management project, which will determine the fate of the expansion of the McArthur River Mine. That sits on the desk of the NT Minister for Mines. The Northern Territory EPA recommended approval. in spite of the mine's environmental record, in spite of the independent monitor's findings of uncertainty and the speculative nature of the solutions proposed, and also ignoring the Northern Land Council's submission, noting that none of the specific environmental objectives, standards or closure conditions are seriously influenced by Aboriginal views and values. Moreover, mainstream and fundamental concerns that were clearly anticipated and documented in, for example, the 2006 assessment report by the agency equivalent of NTEPA and recurring reports from the independent monitor, also appear to have failed to have a meaningful influence on the current approach. That raises fundamental questions about the capacity of the Territory's assessment and regulatory frameworks to deal with large-scale projects and their effectively irreversible impacts on landscapes and lives. Community opposition and anger remain, and the NT Government continues to hold an inadequate bond to remediate the site. If I had to bet, Glencore, having created a 1,000-year problem or an in perpetuity problem in 10 years, it'll get its approval. But would the outcome be different with the revolutionised environmental impact regime I've described? If the 2005 consultants were independent of Glencore, having been selected at random out of a pool of independently accredited experts, if those consultants had had to provide decision makers with a statement of compliance against best practice? Would it be different if the cultural outcomes and impacts in the Gulf had been considered in the kind of way they were by Chief Justice Preston in the Rocky Hill case? If issues like distributed inequity were interrogated? Would it be different? Would it be different if all of those matters could ultimately be interrogated in a way that is depoliticised in a court and judged by someone impartial? I suspect the answer to that question is yes. I hope the conference is both challenging and rewarding. Viva la révolution. Thank you.